Hi friends, hello. Today we're going to be discussing most interesting immigration news. I will be sharing with you court updates, very important court updates for those of you who would like to stay on top of immigration developments in the United States. They are essential. You need to know them. We're also going to talk about fines that DHS started imposing on undocumented immigrants. And of course, I'm going to share with you some other interesting developments. And in the end, I'll be answering your guys' questions. So thank you very much for joining. Please don't forget to like and share the stream. If this is your first time here, welcome. My name is Alena Shautsova. I'm a New York immigration attorney. I use my social media to share immigration news, my thoughts, tips, and to answer your guys' immigration questions. So, guys on TikTok, thank you very much for joining and sending your loves. Thank you for sending your hearts. Please don't forget to type up your questions so that I will be able to read them in the end and answer them, helping you guys out a little. Don't be shy, say hello. Let me know where you're watching from. And let's start. Well, I'm going to start today with sharing some very important court updates. We have a number of decisions by the United States Supreme Court and by the Board of Immigration Appeals. Board of Immigration Appeals, this is the high level of immigration courts. This is the place where if your case was denied in court by immigration judge, you're going to be filing an appeal to. And very often, well, then nationwide, it means that their decisions, published decisions, must be followed by both the USCIS and by immigration courts nationwide. Okay, that's how important Board of Immigration Appeals is. So, decision that came out recently concerns those of you who entered the United States on a parole, where if you were released rather to the United States on a parole 212 D5 parole. Typically, people would have this type of legal entry when they would seek parole at the border, the southern border during the Biden administration, whether through CBP1 app or by crossing the border if they would be apprehended. And we all know, or some of us at least, that if you have this 212 D5 parole and you are an arriving alien, for example, if you marry a US citizen, you can adjust status, for example, right? Because that would be considered a legal entry for the purposes of adjustment of status. So, that's what it was. And people very often would be placed in regular removal proceedings after that, not expedited removal proceedings, allowing them to apply for various forms of reliefs from removal. But the decision that came out addresses a very important issue. It answers the question whether or not a person who was allowed to enter the United States on this 212 D5 parole, if that parole is taken away by the government, are they free to go? Can they file for bond? Or will they be in immigration detention until their case is decided? Board of Immigration Appeals stated that once the 212 D5 parole is lost, the person may be subjected to immigration detention without any opportunity to seek bond. Knowing that what is about a million of people entered the United States on this parole, this is terrifying for them. Unless they were able to fix their status by now through marriage to a US citizen, maybe other family petition that would allow them to fix their status, asylum, that were the most common options. Now, if USCIS, not USCIS, ICE, revokes their parole, they will not be free to go. They will be placed in immigration detention. Very important decision. Well, it's again, it has other potential consequences as well beyond this stream, which if you're an immigrant and you enter the United States on this way, if you had this 212D5 parole, you should speak with an immigration attorney. You have to have something going for yourself in terms of how you're going to be fixing your status, not to be arrested. Very, very important by immigration authorities. Another important, very important developments are coming from the United States Supreme Court. One of them concerns Alien Enemies Act. That's very old law that Trump's administration wanted to use to quickly deport people. Well, guess what happened? The United States Supreme Court, the main court, stated not so fast. You cannot use that law to basically deprive people of due process. So it didn't say that you cannot deport people. Of course, any administration can deport a person who is in the United States unlawfully, but they said that they nevertheless, under our laws and constitution, enjoy certain due process rights that they cannot be taken away, even if you're trying to use this Alien Enemies Act. An important decision. If you are watching my streams regularly, at the very beginning of this new developments, I did tell you that there will be a period of time, a short period of time, the first 6 months, with certain people going to get hurt by new immigration policies, because the reaction, the stop of the new immigration policies that potentially violate your constitutional rights comes a little bit later. And that's exactly what is happening now. The first group of immigrants that were deported under the act are already out of the United States, and they may never probably re-enter back. But those who were managed to hold on will probably remain up until they're provided due process rights and an opportunity to defend themselves. Now, we also know that on May 15th, the United States Supreme Court heard arguments in very famous case related to birthright citizenship. For many of you, it's a very important case. You all want to know the updates. Why? Because you're immigrants and you would like to know if your kids born in the United States or are going to be born in the United States will remain to be US citizens, right? So it's a very important decision, very important issue. However, this particular time, the United States Supreme Court was answering or tried to hear arguments, rather. They will answer this question a little bit later. Arguments related to this problem. You know how a federal judge in New York makes a decision related to immigration and all other states must follow it? So the government would like to change that. They would like to argue now, this administration, that if a judge in New York makes a decision about DACA, for example, or about birthright citizenship, then that decision has to be covering that location only and not nationwide. It means that if a person would want to fix, living in Texas, would like to fix their status or have the same treatment as the person in New York, they would also have to sue the government. And not all, from what I understand, excuse me, United States Supreme Court justices are in favor of that. They do believe that we do have precedents, previous decisions that firmly established the nationwide coverage after certain immigration-related decisions are made by the judges. But some justices indicated we do not know what's going to happen, that they may rule in favor of Trump's administration. Extremely important case, guys. We're going to, follow what's going to happen, how they will decide it. Decision is expected to be in June. And of course, don't be a stranger. Sign up for my social media because I will share with you updates as to what eventually is going to happen. The decision, again, potentially may affect not only birthright citizenship, but any and all immigration issues. that are presented before federal courts. So that's what's going on. Now, let's go to some interesting news related to fines. Fines. DHS, and again, if you are with me for some time, I did discuss this, that Trump administration stated they would like to utilize the law and impose civil penalties, fines against people who, for example, in this particular situation, did not depart, did not leave the United States after they were ordered deported. And guess how much they counted? You have to pay them $1,882,000. So it's $1,820 something thousand dollars, almost $2 million. They stated this undocumented woman from Florida who was deported back in 2005 should pay this money. Well, she doesn't have this money. I remember during the announcement, President Trump stated that they're going to go after your wages. But if you're deported, you don't have wages in the United States to go after. I mean, they probably can take some of your possessions, maybe your jewelry, I don't know. But yeah, 1.82 million fine for failing to leave the United States after 2005. That's some hefty fine. You need to know about that. I do not know how it's going to be enforced. Most immigrants don't have that much money, obviously, but there are also rules about how a judgment against a person may be enforced. So we're gonna see what's gonna happen with this. But you need to know that it started happening. And another very bizarre news, I have to tell you. A reality show where immigrants compete for US citizenship is being considered by DHS, Department of Homeland Security. Just to provide you accurate information, I went back to my books and I started looking up, do we have a basis for citizenship for somebody who may win after they participated in a contest, in some kind of a reality show, and the prize would be the US citizenship? I couldn't find a basis. With that being said, maybe I do not know something. Maybe the government is going to create a new basis for US citizenship, like this competitor in Lost or something, right? I do not know how they're going to call this show, but that's something very, very strange, I have to tell you. But apparently, it's a real thing, and they may come up with this show. So what they have in mind is that they're going to determine what is to be an American, what traditions you have to follow to be a true American. And then people will participate in different, I guess, artificially created traditions. And those of them who are showing themselves to be the best will be awarded the United States citizenship. Here we go. That's the new development. I guess immigration reform is coming and is happening, but not the way we would hope it would. And now, guys, if you have questions, I'll be very happy to answer them. All right. Hi, Brian. I have my final hearing in August, but my judge rating is 25% and my fingerprint is not done, so what can I do? Well, listen, the thing is this, you typically cannot change a judge just because you want to change the judge. You can change jurisdiction sometimes, but also you cannot shop for jurisdiction intentionally. But let's say if you truly moved to a different place, different jurisdiction, you can file that motion to change venue. And very often it may be granted, right? If your lawyer does a good job and demonstrates that you truly moved and the government is not prejudiced by this move, and then you're going to appear before a different judge in a different jurisdiction, right? 25% approval rate is the below national average, just so you know. And you said your fingerprints are not done. Have your lawyer requested fingerprints? Did your lawyer have to request fingerprints? Remember that after December 26, I believe, of 2024, lawyers no longer need to do defensive filing. The government is supposed to ask you to appear for fingerprints if they don't have fingerprints on file for you. All right. Hi, blessed girl. Do you recommend going around with your real ID instead of your green card? Guys, under the law, you must carry your green card on you. So I cannot, as an attorney, tell you not to take it with you. Okay? Real ID is different document. It is a different document from your green card. Green card is a real ID compliant document, but real ID is your driver's license, and during the process of receiving the driver's license, your immigration status was verified, and it's indicated as such by little star in the top right corner of your ID. Okay. Thank you, Clayton, for your kind words. Hi, Alena. What about people that start a LULAC process and ask to cancel? What will happen to these people? Well, LULAC process was a very old nowadays relief, for 40 years old. People were usually using it about 30 years ago, right? Now, there was a lot of fraud involved with that LULAC thing. And from what I recall, reading Kurzban books on that particular issue, the government stated at some point that people who filed for LULAC, that's how I pronounce it, maybe somebody pronounces somehow differently, they would not be punished if their application was not granted. Okay? So I think you'll be fine, but you have to watch out for other issues that may be that you may have in your case. All right. Now, guys from TikTok, let's see what documents you have, what questions you have. Let's see. Thank you guys very much for your likes. I'm from South Africa. I'm abandoned here. What? What's going on? Thank you for your gift, but let me know what's happening with you. What's going on? Can you file, hi Leah, can you file a motion of opposition if they want to reopen your administrative closed cases? You bet. Yes, you can. But you're going to have only 10 days for that, so watch out for those notices. Hi, B Africa, dismissed domestic violence, no prejudice, then became lawful permanent resident. Will I get in trouble coming back to the United States? Well, you have to have your certificate of disposition for those charges. And if you truly never committed a crime, it was a mistake, whatever happened there, then you should be fine. But if you or anybody confesses under oath to an officer in committing the crime, even if you were not punished for it, that confession serves as has the same effect as if you were convicted. Just understand the law, please, okay? All right, thank you very much, Samuel. Hi, Mohammed. I feel at ease now to travel to Jordan on my green card. I have no courts or cases. Okay. Hi, Khalid. What about refugees coming to the United States? I reported on that a while ago, that there was a federal court decision that Trump administration will have to take about 12,000 of refugees that were previously said not to be allowed into the United States. I didn't see any updates about that case, so I presume that the decision still stands. Okay. Can an immigrant travel between states by plane? Yes, you can. You may be asked to produce what's called a real ID compliant document, but your foreign passport is a real ID compliant document. All right. Thank you, Fabio, very much for your gift. You are welcome, guys. All right. How long does it take to receive a letter after winning an online defensive asylum hearing? Receive a letter decision by the judge? Well, hopefully it's going to come like the same day, next day, or um, within a short time. If the judge gives you a short form decision, it's very easy for them to print it. Okay, it's nothing. It's like really easy for them to print it. If the judge would like to make the decision more elaborate and explain why they're giving you asylum, well, then you have to wait for a while because it takes them time to type it up. Okay. All right. You are welcome, guys. Hi, Prince Basir. BIA remanded case to USCIS, but they're taking too long to make a decision. Can we sue them? Can you sue them? Well, I guess you can, but I would be cautious about that right now. I wouldn't be doing that. Why don't you try working with your congressman first? All right. Hi, Gek N. It has been 3 weeks since my 221G case placed under administrative processing. Is there any way to expedite it? Oh, I have bad news. 3 weeks for 221G is nothing. People may be stuck in that process for years. All right. Can you expedite it? Sure. You can contact the embassy and provide them information they're looking for because 221G usually means they're looking for something, trying to check your background, trying to verify your employment or something else. So if you guess what is it that they're looking for and you give it to them, then the process will be faster. Hi, Kelvin. Are they still doing joint motion to reopen in 2025? And normally, how long on average does it take? No, they are not doing it as widely as before, but in certain cases, certain very specific cases, they would do that. People who traveled on TPS, for example, maybe some SITch cases, but it's no longer a normal thing to see. All right, it got much harder to receive government consent for reopening. Hi Malik, is there any chance getting detained and the interview with I-130 approved and don't have removal orders? Yes. If a person has criminal convictions, they may be detained. Yes. It's actually exactly the cases that were reported why people were detained. Okay. Hi Prosper, I'll be going to ICE office in Baltimore for reporting requirement. I did credible fear and I have applied for asylum. Will I be detained? Because I was released from the camp based on parole. Will you be detained? Not necessarily. The government has to have something on you, usually, as to why they would detain you opposed to a guy next to you. Usually, it would be a violation of your order of release of that parole. Criminal charges, right? Maybe something else. Maybe you posted something online. These days, it seems you can get into a lot of trouble, even if you're a former FBI director, if you post something online. So, things like that, all right? If you don't have anything and you really just followed all the conditions of your order of supervision, typically you will not be detained. Make sure that you update your address per order of supervision requirements and requirements in courts. It's very important, right? Always update your address. Hi, Wakar. May I adjust status if I paroled on the 212 D5 through which program? Marriage to a US citizen, you have to be an immediate relative, or you have an adult son or daughter, US citizen, 21 years of age, or vow perhaps, right? Hi, Danny. I wrote 2 letters to asylum office and still didn't withdraw my case. Can I file a mandamus lawsuit? I wouldn't be filing a mandamus lawsuit, Danny. Why do you need to have that case withdrawn so badly? The thing is this. Your pending asylum case does not prevent USCIS from granting you green card based on marriage if that's the situation. All right, it just doesn't. So I think you'll be fine. We used to have an opportunity to visit the asylum office in person. During COVID, they stopped that practice. And I do not know if they restarted it. I do not know where you are at, but work with your attorney, see maybe you can come to the office and speak with the supervisor if you really want to have it withdrawn. All right? All right, let's see. Can you help Afghanistan people? I can help people who are in the United States, guys. Those people I can help. If you're out of the United States and you're seeking parole, unfortunately, they don't have that program anymore. All right? And I'm largely useless for those of you who are seeking special immigrant visa. I know that a lot of people, many people from Afghanistan, worked with the United States government and military, and now they have trouble proving that or trouble receiving those authorizations for special immigrant visa. But no lawyer will be able to help you in the situation when the authorized government official does not sign that certification for you, unfortunately. Okay. Hi, IDCB. Can I file for lawful permanent residence immediately after winning defensive asylum hearing? Well, technically you can, but I wouldn't recommend you doing that because if the government considers your application within 1 year of you winning that asylum case, and by the time they're making their decision, you have not accumulated 1 year of physical presence in the United States, your application for a green card will be denied. All right? So I would wait for at least 6 months afterwards. How long does asylum take before permanent residency is granted? Not sure what you mean by that. They're not like necessarily connected. The asylum process in the United States is different for everybody. Some people may be stuck in the process for 10 years. Some people go through the process very, very fast. It depends on jurisdiction, depends on how you entered the United States, when you entered the United States. It depends on the judge in your case. But on average, I would say it takes at least 5 years, okay? Some people may go through the process swiftly, 1 year. It happens in rare cases. But in most cases, you will have to wait at least for 5 years, and some cases even more than that. All right? Thank you, Rashad, very much. All right. Hi, blessed girl. When you change your address on USCIS website, do you get a response? How do you know that they received it? Well, yes, you're supposed to receive a confirmation. All right. You're supposed to receive a confirmation. That's how you would know that they received it. But what you need to do is you need to save screenshots of you doing that update. Because if they send a notice for your case, the old address, and you never receive it, and then they deny your case, at least you will have a defense and you would say, wait a second, I did inform you that I moved, all right? Hi, Malik. I-45 plus 601 interviews still could get detained. I guess under some circumstances they may be, right? They may be. Hi, Olga. Is it safe to apply for adjustment of status with these two charges below? No, it's not safe. You need to work with an attorney, all right? I see that something was dismissed, but you still have to work with a lawyer. As I explained here multiple times, guys, understand. What happens with criminal convictions and immigration is this. For immigration purposes, you may be regarded as a convicted person, even if you are not for criminal purposes. It's really weird. If for criminal purposes, for example, you suffered any form of punishment, anger management classes, a little fine, for immigration purposes, a very conservative officer may still see you as being found guilty of something. All right. In addition, if a person confesses when they are under oath before a government officer, saying that, well, yeah, I just hit my girlfriend, but it wasn't a big deal, okay? Charges were dismissed afterwards because we made up. That person just found themselves guilty of domestic violence, all right? So that's how it works. This is just a very primitive example, but you need to keep in mind that for immigration purposes, it can be different than for criminal purposes. Charges dismissed in New York, for example, ACD, adjudication and contemplation of dismissal. For criminal purposes, you don't have a conviction, right? But for civil purposes, but for immigration, sometimes it can be different, right? Hi, I so far, Alexa. Recently married, waiting for interview, received workers permit. Nervous for interview. Why are you nervous about the interview? You just need to prepare well. We just were able to win a tough case for a client who was not our original client, and I think they had several lawyers working on the case. But I was surprised that attorneys were submitting I-130 and they were charging good money for what they were doing, I understand. But it was garbage. Like there was no good evidence showing that people actually lived together, and they didn't hit the most important points. What are the most important points when you submit I-130 case based on marriage? You have to show that the couple lives together at the same address. Lease. If you don't have that lease, you have to produce an explanation as to why you don't have it and what's going on. IDs showing the same address. If you have IDs and your spouse says that they live in Washington and you live in New York, well, you're going to have a problem, okay? Joint tax returns, joint utility bills. These are the commonly looked for by USCIS documents that they pay attention to. That's how they determine, in their minds at least, if you have a real marriage or not. Not only, but these are important documents. But if you don't have these documents, then you have to literally produce anything and everything that you may have, proving that you actually live together. And you have to take it very seriously. Why? If you watch me for a while, you know why. In immigration cases, there is marriage-related cases, there is no gray area of maybe. It's either your case is going to be approved or your case is going to be denied. And if the case is denied, they usually deny it, accusing you of immigration fraud, unless they can accuse you of not being legally married to a person, which happens sometimes as well. There is such a category of cases where you cannot prove that you were divorced from someone. Then they deny you based on a different ground. But if the case is denied, I-130 is denied. In 99% of situations, non-citizen is accused of marriage fraud. And the door for their green card in the future is shut. Like that. That's it. Okay? So it's extremely important that you win that I-130. Don't file for it if you don't have enough evidence. Even if you have a real marriage. I meet couples after couples. They have really real relationship. Not perfect, but a real relationship. Very often they casually thinking that somehow it's going to work out, and they may overlook this evidence. They don't need to collect it. They don't have to produce it. Trouble comes. In the end, of course, if they have me as an attorney, we win. But it takes them thousands and thousands of dollars, hours and hours of work, and sometimes a very long time. Okay? And there are some lawyers who just don't know how to win. That's also the truth. And a person, instead of getting a green card, is going to end up in immigration court removal proceedings with this horrible charge of fraud, which it's devastating. It truly is. 204C is one of the worst charges in immigration cases to deal with. All right. Hi, Eduardo. Is filing I-601A waiver still advisable in 2025 when it's your best option? I have heard of NTAs after filing. Eduardo, I've never heard of NTAs after filing for I-601A waiver. If you don't have any other issues in your case, absolutely go for it. Some people ask me, is it a good time to file for anything? I'm going to tell you, it's a bad time not to file for anything. Because if you will meet trouble, if you don't have anything going on for yourself to fix your status, it means that nothing good is going to come. You won't be able to ask for a stay of removals. There is nothing to ask for. You won't be able to ask the judge to give you more time because nothing is pending. So if you don't have any other issues, yes, you should go for it. Okay. All right, let me answer a couple more questions, guys, before we go into part. All right. Hi, Eyes of Alexa. Thank you very much for that information. We'll be able to provide those documents and more, but those documents are the bare minimum that you guys have to collect. That's very important. Take it very seriously. Every piece of paper you have with your husband, you type, honey, pick up milk, save it. Because only if you're a crazy person, you're going to send somebody a text to pick up the milk when you're not living with them, right? So save those texts, okay? Texts about nothing, about the milk, all right? All right. Hi, Rex City. I have been waiting for an interview for 8 years. Applied for asylum. Okay, that's common. Yes, 8 years you can be waiting. Sometimes people are waiting for 10 years. But recently, I think people who filed in 14, 15, they finally started getting to those very old cases. Again, if you watch me, I'm like a parrot today. I repeat the same thing. If you filed your case long time ago, asylum case, and now you're called for the interview, what do you need to do? You must update your case. At the minimum, you have to update your story. At the minimum, you have to update your country conditions. All right? Very, very important, guys. Please pay attention to that because the officer who's making a decision will be looking at it like this. 10 years passed. Why are you still afraid to go back? Tell me more about that. What happened? Anything happened recently to friends, family, anything in the news? How's country conditions? Did country conditions change? Oh, by the way, did you get yourself a country conditions expert? All right. So all that is very relevant. Make sure that you're going to update your filing. And of course, if you're updating a story in writing so that the officer can read as to what new information you're going to share with them, they have something to compare your testimony with. Okay. Otherwise, they will listen to you. Of course they will, but they will 100% send you to court and say, deal with the judge. All right, guys, thank you very much for joining today. Thank you for your questions, for your likes and shares. Please don't forget to follow my social media so that we're going to meet with you again. If you are watching me on TikTok, follow on TikTok, on YouTube, you subscribe, and on Facebook, of course, as well. Throughout the week, I also share updates about the most important developments. Very, very important, right? To stay on top. Why? Because you may have a court case coming up, you may have a USCIS pending case, or you would like to file for something, and you really need to know what would be the prospects of this or that situation for you, and how to maybe adjust your actions to make sure that you are going to reach your immigration goals in the United States. Well, guys, thank you very much for watching. I hope you're all going to have a very good, restful Sunday, and we'll see you guys next week.